Hello and welcome to a fresh new episode of Big Deal. I'm Nisha Poddar. Now remember, the path-breaking insolvency and bankruptcy code has been recently notified. It promises to really resolve the huge issue of stressed assets in the country and support banks in the NPA resolution. It's early days and it will have to go through its own implementation curve, which may face, remember, its own set of challenges at the inception stage. But in the end, whether it can really resolve the issue of debt-laden companies better than the many other statutes which are operational currently and the many guidelines prescribed by the Reserve Bank of India is to be seen. We have with us a panel of experts who have been working on this very closely and can throw more light on the complexities of insolvency and bankruptcy law. We have with us, and let me introduce all of them. We are a very well-known corporate lawyer, Shardul Shroff, is right here with us. Joining us is also Mr. M.R. Umarji, who has been instrumental in formulating the bankruptcy code. He was also on the board for SARFAESI as well, and has been associated with IBA. And last but not the least, Mr. Manish Makaria, who's been an investment banker, is currently the managing partner at special assets advisory firm Brescon Corporate Advisors. Gentlemen, so good to have you on the show. Now first, coming to you, Mr. Shroff. Is this a well-thought-through code in terms of the legal framework? And do you think it will be a game changer when it comes to resolving the NPA situation and the distressed asset situation for the banks as well as for corporate India?
I think it is clearly a change from the past. The process is pretty ambitious. I feel like every major legislation, this will undergo its challenges. So my own perception is that it will take 3 to 4 years to stabilize till the matters really get resolved right at the Supreme Court level, because there are many challengeable sections. So it will have its own hiccups. But yes, it's a game changer once all that is through.
All right, so it will go through its own learning curve and the trial and error, and of course through court settlements as well. We'll come to each one of those issues in a bit. But Mr. Umarji, of course, there have been many such path-breaking statutes which are currently operational. Of course, SICA has been repealed, but as we understand, there are others which are also complementary, like RDDB Act, SARFAESI. All of them are still there, and the Reserve Bank of India very recently has also come out with non-statutory guidelines in this respect as well. We've seen CDR, SDR, S4A, all of them. How is it going to really work as an interplay with all that is already operational, and how will it find its own space in resolving the issues?
You see, the insolvency process is going to start immediately after default. So if I commit default today, tomorrow insolvency petition can be filed against me. That's how the provisions are made. As against that, SARFAESI Act is after default of 90 days and the account getting classified as NPA, then only the process of action under SARFAESI can start. Similar provision, although classification as NPA is not required, the debt recovery tribunal action will also be normally after there is a effort made to recover. If the loan can't be recovered, then finally you will go to the tribunal for recovery. Now, all this will continue to be operative even after insolvency code has come into force.
Yes.
And there is a provision in section 14 of the insolvency code which says that all these actions will be stayed. There is a moratorium of 180 days once the insolvency petition is admitted. So no action under SARFAESI can be taken, no action under DRT Act can be taken during the pendency of a insolvency resolution application, on which orders are to be passed, whether an insolvency resolution plan is to be approved or not approved. So long as the petition remains pending for 180 days or an extended time of another 90 days, no action under SARFAESI or DRT can be taken. So there is no conflict. As far as RBI schemes are concerned, they are basically not statutory schemes, they are directions of Reserve Bank of India. If any scheme is worked out under that scheme, it can continue to be operative under independent of an order from an insolvency court, the National Company Law Tribunal. But it is also possible for the banks to formally place it before the National Company Law Tribunal and get an order for insolvency resolution plan in terms of the settlement agreement that has been reached between the company and the lenders.
All right, so while we are trying to untangle all that complexity, Mr. Makharia, you've worked on many distressed asset situations as an investment banker as well, and you have specialized in this particular area. How do you see this particular bit of the interplay of various other statutes as well as guidelines really playing out, and what are the challenges in implementing the law?
Before I get into sharing my thoughts on that, I think one of the important point and the intent behind the law is worth highlighting. I think more than, calling it insolvency and bankruptcy kind of a situation or a liquidation, this is more of recovering the value from a stress situation. So I would put it a bit more positively. It's a comprehensive law which has been formulated by the government to see how in a timely, in an efficient manner, we can help business to turn around, revive. So it's more of rescue and recovery.
Do you think insolvency professionals would really have the bandwidth to also turn around the company and rescue the company operationally? Because it's the finance background from which everybody comes through. And if the promoter is ousted, how is it going to really work out? Because in SDR mechanism also we tried to do that and it hasn't really worked out.
I think we will have some challenges in terms of, operating the company for 180 days or 270 days with administrator with certain background and there being no promoter to run the company. Having said that, in many of the situations, I think, you will have professional CEO, interim management, which will step in to support the administrator. But I think it is only over a period of time we would know how really, this process is being led by an administrator, both on the financial and the operating turnaround aspect. Having said that, I think, yes, the country will need such talent, and one of the softer provision under the law is it permits foreign nationals to also act as IP, provided they comply with certain condition in form of number of partners in a firm which is being registered and so on, which basically means people who have got relevant experience maybe outside the country in other geographies, one can leverage that pool of talent too.
How do you really compare this with Chapter 11 in the US, and it is more tilted towards the UK law on bankruptcy terms. So is it tailor-made in Indian context? Is it more...
US law is debtor in possession, where there is no problem. He will continue the business and also prepare a resolution plan. UK law, and it is creditor in possession, which is the concept which we have adopted, and it's a new experiment as far as our law is concerned. All the winding up cases in the past were conducted by the official liquidator, who is an officer of the court, and this is going to be replaced by insolvency practitioners. It is for the first time that we are trying this new system. It will have to settle down and how it works in practice. And as far as it may be necessary that these insolvency practitioners who are professionals will have to engage some other experts who then you may have to manage a company which is making hazardous chemicals. And you may have to have a person who knows how to handle that company.
Yes.
And this is one aspect. And the other side is that as far as the company is concerned, if it doesn't come out with a resolution plan within 180 days, it is going to lose the company.
Yes.
The company is going to be liquidated if resolution plan is not passed.
Right.
So therefore it is in his interest that he cooperates and sees that the things continue to work.
Again, I will raise the same point, and Mr. Shroff here, I would look up to your expertise. Again, SDR had 18 months window. There again, we thought that the promoter would work with the creditors really for the resolution. But here, it's the same situation. In 180 days, is it a doable timeline?
I think the important point which Umarji mentioned was that there is now a sword on the heads of the promoters and the company. If you don't come up with a plan in 180 days, it is an automatic insolvency trigger. So the question therefore is that the luxury of time which was available under SICA or any of the RBI directives is no longer available. and if you don't get your act together, then you're facing down the barrel of insolvency. I think that is itself a good trigger for companies to really move into a swift gear and come up. I don't think it's only the company's issue also. What will happen is that the public sector banks and financial institutions, which have their own decision-making process, which is pretty slow in many ways, they will also have to gear up and change, because they could also be dragged into insolvency and have to prove that they are secured creditors outside winding up, or take up any of the three options that are available to secured creditors. The ability of a financial creditor, which is not a secured creditor, to really change and alter the process is also a new element of this law.
Of course.
So that also has, it's not just, unlike in the Companies Act, it was only the secured creditors who used to be outside. Now, in the class of financial creditors, you have both the secured creditors and other financial creditors.
So they both are at the same key.
Yes.
And how does this work?
It has, therefore, the process of how you create new arrangements between financial creditors, operational creditors, secured creditors is going to be a matter of art. It's going to be a matter of negotiation, and I think it is all to be seen in the background that this is time bound, either 180 days or 270 days, and if you don't achieve it, there is no power of extension. The Act proceeds on absolutely a clockwork mechanism. So if you don't finish, too bad, you're wound up.
All right, so you have to be extremely efficient.
Yes.
In fact, the entire system will have to work towards it.
Absolutely.
Okay, hold your thoughts, gentlemen, and we will come back with many, many intricate details of the insolvency and bankruptcy law. Stay tuned to Big Deal.